Okay, so this morning we are talking about strikes, and I just normally when I start these things, I sort of do a bit of crystal ball gazing. So just looking at this morning's newspaper, we start looking, unemployment rises to a 13-year high. The figures range between 36.3% to, and I just quote from this morning's Independent Business Review report, joblessness rate is at a record high of 43.2%, according to the expanded definition of unemployment. So against that background, we're talking about strikes. Interestingly, GDP is also up, which is a good thing. And looking at some of the other indicators this morning from the newspaper, the Rand dollar rate is at 13.76. So 13 Rand 76 will get you $1. Again, probably not due to anything wonderful that we're doing as a country, but because of Mr. Biden's presidency, the Rand is strengthening. Resources are all up except gold. The all share index is up. It's at 68,922.9 points. And the price of Brent oil is at 71.15 US dollars per barrel. So again, the price of oil is an indicator as it rises, and you'll recall it came down to well under 40, about $40 to a barrel about 2 years ago, from its all-time highs, and it's steadily climbing. And that's also quite a good indicator of the world economy. When the oil price starts to rise, the world economy is getting better and better. But from a strikes point of view and a demand in terms of increases point of view, if you look at the South African scenario, costs of the majority of employees, people employed in this country, what's their major expense? Probably travel, because they travel such long distances to work. So as the price of oil goes up, so their costs of travel also go up. Although with the strengthening of the dollar, the petrol price is coming down slightly this month, diesel staying the same, but in the long term, my crystal ball tells me that the Rand will weaken, the price of oil will continue to rise, which will result in greater expenses to the majority of employees who have to travel vast distances, and the bulk or a lot of their costs on a month-to-month basis or a week-to-week basis are tied up in transport. So there may well be some legitimacy, for want of a better word, for demands for increased wages or salaries. But against that background, as I started by saying, inflation is down to an all-time low. I think someone said to me the other day it was at a 30-year low. So with the inflation running at 3%, how can one demand anything more than 3%? Because one would expect that most people are earning a living wage. Having said that, one must also look at where the real problems are in the country, and that is the most vulnerable of the vulnerable, which the government continues to try and address through legislation. But one has to measure, so people like domestic workers, farm workers, people who aren't subject to any bargaining council rules, or who the department, or just slips through the Department of Labor net, people just pay bottom end wages. Weighed against that must be the argument that to create employment, people want to work, they should be able to work at whatever salary they agreed to, but slave wages or bottom end wages clearly are not on from a moral or ethical perspective. So that is the current status of, in a nutshell, the world economy, South Africa, and whether or not there should be increases or not. It's difficult to see where the barometer of wage increases is, but if one has a look at general increased demands, MEIBC are about to start negotiations. Yeah, they are not the normal outrageous demands, but they're well over inflation. 15, 20% seems to be the run-of-the-mill demand. And from a strategic point of view, one asks the question, well, maybe employers should simply say, well, we're not negotiating, we just will give you at best for you what inflation is and avoid all the pain and suffering of negotiations and what comes out of it. But of course, I'm being provocative about that. We're talking about the strike season, and negotiations are a process and something that we all need to endure, be it annually or depending on whether you're party to a long-term 3-year, 2-year agreement, which cycles those wage negotiations. And just by way of interest, not that it has much applicability to most of you, you will recall that there was the judgment of the Labour Appeal Court late last year. It was a judgment of Dennis Davis, the TV personality, a very clever judge who has an interesting spin on life. And you will recall that the public servants, for want of a better word, were talking about a strike, and there was an attempt to interdict the strike, and the dispute eventually ended up in the Labour Appeal Court, and there were 5 applicants in the Labour Court and 14 respondents in the Labour Court. So the lawyers were having a field day, and the who's who of the South African legal fraternity all appeared in the Labour Appeal Court when the matter was heard by 3 judges. And as I said, Davis, Judge of Appeal, gave his judgment. And it was quite a startling judgment, actually, but quite interesting. So as an old-time lawyer who thinks about employment, thinks about contracts as an offer and acceptance, and in simple terms, the Constitutional Court recently has held that there's an element of fairness even to commercial contracts. And now, if you have a look at Dennis Davis's, and I think he's jumping through loops, and as an old-time lawyer, the old principles of estoppel or ostensible authority, I wonder where those went to in his thinking, because he is a proper, clever jurist, educated in old-time Roman law, Roman Dutch law, but he seemed to forget about that and found a way to find that there hadn't been proper authority given for the wage increase. In other words, those that negotiated the wage increase hadn't jumped through the necessary loops, and on that basis, the 3-year agreement was unenforceable. Very clever. One wonders whether it will hold muster when it eventually gets to the Constitutional Court, if it does, because hot on its heels, there is a similar dispute by the employees of PRASA, who again, PRASA have refused to implement a 3-year agreement. PRASA circumstances are slightly different to the public service, although it is a parastatal, but it'll be interesting to see whether those same principles apply when PRASA eventually gets to court. So that's just as an aside, but also interesting when it comes to deal with strikes. I'm going to talk largely about violence because I think it's the hot topic and an area of law which is developing. But I just want to rehash something about protected and unprotected strikes. So protected strikes, we all know that it must be an interest dispute that gives rise to a strike. It cannot be a rights dispute. Rights disputes are arbitrable through the CCMA or the Labour Court, and only interest disputes are strikeable. And I will come at the end and I will talk briefly about the issue of functional to collective bargaining, which I think is an interesting topic on its own and may well develop the jurisprudence on the right to strike, and some interesting cases that I've been involved in where we are testing this issue of functional collective bargaining, which will probably end up in the Constitutional Court 5-6 years from now, but we'll deal with that in some more detail later. The issue of ballots has also been a hot topic, and it started where there were amendments to the LRA, and the amendments in a nutshell were that unions were required to have a provision in their constitution that they would ballot. Hot on the heels of that amendment came two urgent interdicts before Judge Gush. And I just wanted to mention Judge Gush has retired, and I heard late last week that Judge Farrell is also retiring. So two senior judges from the Durban Labour Court are retiring. They will need to be replaced. One wonders who their replacements will be, but at least with Judge Gush and Judge Farrell around, they were, as I referred to them, two old grey heads, and that you knew what you were in for when you came before either of them. So we're in for an interesting time ahead as replacements come about for both of those judges. Anyhow, Judge Gush heard that there were two matters. One was Marley Burr, an automotive component manufacturer, and the other was Foscor, a fertilizer manufacturer in Richards Bay. And they both brought interdicts against NUMSA on a whole lot of reasons, setting out why the particular strike was unprotected. Judge Gush, off his own volition, which he's entitled to do, said, but there's been no ballot. And on that, in a nutshell, on that basis, granted an interdict in favor of Foscor and Marley Burr and held that the strike was unprotected because there had been no ballot, and NUMSA's constitution did not contain the provision for a ballot. It would be quite interesting, and not many unions have balloting provisions in their constitutions, and the Department of Labour are clearly doing very little to make sure that, so not the Department of Labour, the Registrar of Labour was doing very little to ensure that trade unions amend and update their constitutions to provide a provision for balloting. Historically as well, those of you who have been around for a while, you recall that going back to before the days of the LRA, employers took every technical point in the book dealing with ballots, and the word ballot to trade unions when it comes to striking is a bit of a swear word, and that's not something that they particularly like to do, and probably largely based on the response that they received from employers in the bad old days of the past. Anyhow, the Marley Burr and Foscor matters then wended their way to the Labour Appeal Court, and the Labour Appeal Court found that Judge Gush was wrong on the requirement of a ballot. And I think that the Labour Appeal Court are absolutely right in that regard. And it was interesting that the appeals were not opposed. And I would suspect that both sets of lawyers knew all along that Judge Gush had been wrong in regard to both of those judgments. Anyhow, the balloting story has now ground to a halt, and for the moment we don't see an awful lot happening on that front. I need to catch up with myself. Secondary strikes. There have been lots of threats of secondary strikes going forward, but I think the most important point to remember with a secondary strike is that the secondary strike, the primary strike must be protected for the secondary strike to be protected. And that's in fact an oldest judgment. It's a 2007 judgment of the South African Local Government Association in SAMU, where Judge Van Niekerk in the Labour Court held that the primary strike must be protected to make the secondary strike protected. Having said that, it's also quite interesting, and at an anecdotal level, I think this year, we now into June, we have dealt with 2 unprotected strikes. So anecdotally, there doesn't seem to be a massive increase in strike activity. It'll be interesting to see as the strike season, as it's called, continues, whether in fact there will be protected strikes or whether employees will be trying to protect employment, protect their income going forward. The other interesting judgment is the AMCU and Anglo Gold Labour Appeal Court judgment dealing with secondary strikes, and this judgment went all the way to the Constitutional Court. What I wanted to deal with at some length today is the issue of violence during strikes. And it's been the old bugbear over time where the resort of employees with the strikes protected or unprotected, and to try and get maximum power out of the strike, is to embark on some sort of coercion of their fellow employees who do not want to strike, or for temporary employment services people who want to strike, or even management people who are not part of the strike who want to carry on working during the strike. The recent judgments, we're going to talk about the WBHO Hlatswayo Labour Appeal Court judgment, and then we're going to talk about Pale Pack and Pale Print, and then again I'm just going to refer to a couple of matters where we as a firm are involved, which may be of interest to you. So the WBHO Construction Hlatswayo and others matter. This was a Labour Appeal Court judgment. It was a judgment of Sutherland. And again, the Labour Appeal Court, Davis, again, Dennis Davis, Sutherland and Murphy, a very strong bench, upheld an appeal from the Labour Court. In other words, they disagreed with the Labour Court, and they found in that case that the behaviour of the employees, it was a small group, it was 21 to 41 employees who were dismissed for intimidation of subcontractors and management, and or engaging in undesirable activities leading to the shutdown of the site on 14 September 2013. So the shutdown was 2013. The Labour Appeal Court started its process in 2018, and judgment was delivered. I'm just looking for the date. Judgment was delivered on the 29th of May 2020. So this case took some 7 years to wend its way through the courts, which brings me to another interesting judgment. It's a judgment of the MEIBC. The employer is a business called Luxor Paints, where they dismissed 189 employees in a protected strike situation. And it's quite interesting. The facts in the Luxor Paints case are quite interesting in that some of the employees were dismissed for derivative misconduct. Those of you who've heard me speak before or know about our firm, we were involved in the case that went all the way to the Constitutional Court dealing with derivative misconduct. And the Constitutional Court found in that particular case that derivative misconduct formed no part of employment law or strike law. More particularly, in summary, the court found that there is no duty, and you'll recall the language of Judge Savage in the Labour Appeal Court when she said there was no duty of employees to rat on their mates, their fellow employees. And in the Luxor Paints case, and the language I've begun to use in discussing these cases is if there are employees who are in legitimate strike, the strike is protected, and they are sitting at home, to quote my words, doing their knitting, end of quote, an employer cannot dismiss those individuals. And that was the finding in the DIP case that went to the Constitutional Court, that if an employee is simply sitting at home on strike, the strike is protected. One cannot dismiss them on the basis that they should have or could have or would have come and told you who was participating in the strike, or participating in the unlawful conduct, and why they shouldn't be dismissed because they weren't participating in the unlawful conduct. So in the Luxor Paints case, which is wending its way to the Labour Court as we speak, there were a group, if I recall correctly, 30 odd who were dismissed purely for derivative misconduct. In other words, they were sitting at home doing their knitting. There was another group who were not necessarily identified in the voluminous videos and photographs taken of people. They were clearly where the action was taking place, but not necessarily participating in the action. In other words, these individuals were never seen with a rock in their hands or a stick in their hands, or actually toying or threatening anyone, but they were part of the action, and they were dismissed on the basis of common purpose. Common purpose in itself is problematic, and the courts have come up with various decisions on whether you can dismiss an employee for common purpose in a strike situation. In other words, they were lurking, they were at the scene of the bad behavior. Again, I think personally that it is quite risky, but if you have video material that actually identifies people, and both the pale pack and pale print judgments of the Labour Appeal Court, the pale print judgment is an award of arbitration of Richard Lister, and the pale pack award is a review and an appeal of a judgment of Lisa Williams de Beer, both of whom, so matters pale print, pale pack, both matters were arbitrated, and there was evidence at the arbitration that these individuals had behaved badly. They were carrying, amongst other things, golf clubs at a strike, and they were identified. The arbitrator, Richard Lister and Lisa Williams de Beer, reinstated them on review. The dismissals were held to be unfair, and then it wended its way through to the Labour Appeal Court, and in separate judgments. In the pale paint judgment, it's a judgment of, interestingly, Savage, acting judge of appeal, and she was sitting with Murphy and Moosey, both Murphy an acting judge of appeal and Moosey a judge of appeal. And in the pale pack matter, Carthree Ciclione, acting judge of appeal, delivered the judgment. In both those judgments, the Labour Appeal Court found that the behavior of the strikers in carrying weapons during the strikes, and they were aware of the workplace rule in the pale pack matter. There's simply been a notice placed on the notice board telling employees that they shouldn't behave like this, and it was held that the dismissal was fair. The pale paint judgment is slightly different, where the employees were carrying shambucks, PVC pipes and sticks, and they're also the possession of a golf club and an axe. And it was held by Judge Savage that behavior objectively was a message to other employees threatening others, and in that situation the dismissal was warranted. So both those arbitration awards were overturned eventually by the Labour Appeal Court. And again, that's one of the problems that employers face, that sometimes they will lose in the CCMA or the MERBC at arbitration or the bargaining council, and have to wend their way through to the Labour Appeal Court, or to the eventually to the Constitutional Court. Another interesting dispute where this firm has been involved in, where during a strike some 3 or 4 years ago, there was a protected strike, and employees, about 22 of the employees, barricaded the road outside a client's premises. They set up a barricade at about 7 o'clock in the morning with logs across the road, and lit fires, and they were burning fires. And at about 9 o'clock in the morning, a delivery truck tried to leave the employer's premises. It was a cul-de-sac. In other words, there's one way in, one way out, and the truck left, and across the road, this burning barricade was still burning. and there is video footage identifying, and there was never any dispute, both at the disciplinary inquiry or at the arbitration, as to who those individuals were that were standing, toy-toying, dancing, some were threatening with sticks. And the commissioner in that dispute decided that the people on the left-hand side of the road, and bearing in mind the truck had to travel over the right-hand side of the road, off the road, over the driveway of an adjacent business to leave the employer's premises. But the commissioner, for whatever reason, decided that the employees on the left-hand side of the road should be reinstated, and those on the right-hand side of the road, that the dismissals were fair and lawful. And in respect of the shop stewards, which was interesting, decided that they should get some compensation, but that they shouldn't be reinstated. So a small group of them were reinstated with full back pay. A group were dismissed with no back pay, and the shop stewards got a little bit of compensation, but no reinstatement. So anyhow, that decision is now also on review because there's in fact no basis. All the employees were in the road toy-toying. There were fires. At the disciplinary inquiry, the employees who gave evidence suggested that there were street children who lit the fires, alternatively that there were Wonga addicts who had lit the fires, and the arbitrator, private arbitrator, who heard the disciplinary inquiry found that the people who gave evidence at the disciplinary inquiry were just simply dishonest. It was interesting, there was only one individual who gave evidence at the arbitration before the bargaining council, and his evidence was similarly appalling, but the commissioner decided to reinstate him and a small group of his fellow employees who were on the left-hand side of the road. So the courts are grappling with this issue of strike violence, as employers have for a long, long time, because certainly the power of strikes will dissipate once employees learn that they need to act lawfully and behave themselves. What is difficult, though, is when employees live a long way from home and one can't control the situation where they live, and particularly in townships, and when they travel on public transport. But balloting is one effort to try and deal with the violence, and the other issue, the other way to deal with it, is these judgments which are coming out of the Labour Appeal Court, which are showing an absolute disgust and disdain for strike violence. To deal with a more provocative and interesting area of the law, which is going to end itself all the way through to the Constitutional Court, is the issue of functional to collective bargaining. And I have argued for some time that if a demand is unreasonable or outrageous, or the strike becomes so violent that the strike is no longer functional to collective bargaining, that the strike is unprotected, and that employees can simply be dismissed as a group for being on an unprotected strike. I do think that there are a number of loops that need to be got through before one can get to the stage, and maybe the last resort is a declarator by the Labour Court to hold that the strike is unprotected because the demands are outrageous, it's gone on for too long, or the violence is just ridiculous. And then only once that interdict has been, or that declarator has been granted, declaring the strike unprotected, and that there's an ultimatum after that and some sort of process, would the dismissal be fair. And I think if all those loops are gone through, then I am confident that a court, and maybe it's got to be the Constitutional Court at the end of the day, that holds that the strike is no longer functional to collective bargaining, unprotected, and that dismissal is the appropriate sanction. Judge Niekirk in the Soga Sons judgment of some time ago, I can't recall the exact date, but he held there that, quote, when the tyranny of the mob displaces the peaceful exercise of economic pressure as a means to the end of the resolution of a labor dispute, one must question whether a strike continues to serve its purpose, and thus whether it continues to enjoy the protected status. So that's what Judge Vaniko has said. One needs to follow it beyond that to come to a point where there's actually a dismissal arising out of functional to collective bargaining. Yeah, we've been going just on half an hour. That, I think, is what I've got to say. If there are any questions or debate, I'd be interested in what other people think about this issue of functional to collective bargaining, other ways of dealing with strike violence. Generally, I think employees have had enough. I think we've all been through a very tough time, and I think that the strike season will probably be quieter and more peaceful than we've had in the past, thanks to the lurgy, as I call it. Thank you very much for your time.